Sunga, nice to have you here in the Global Living Room.
Thanks.
Thank you for coming. Davor, nice to see you again.
Good to be here, as always.
Mr. Sunga, as an expert for the topic of migration refugees, I would like that we maybe start with this topic that used to be a hot topic until a few months ago. Then COVID simply covered it, and now it will maybe re-emerge. But in general, to understand, what's your opinion about the treatment of the refugees, Africa, Middle East, coming to Europe in general? Are they really protected subjects of international humanitarian law in the first place? Or could we say that they are primarily and in the first place objects of some international power game? What is this identity?
Yeah, thanks. No, I wouldn't frame it exactly in that way as a one or the other. And just to be a bit more precise with this, in international human rights law establishes very firmly, very clearly, as a matter of jus cogens, which means it's a peremptory norm that overrides all other norms of international law. There's certain classes of international law norms that every individual on earth, that includes you and me, has a right to seek asylum in a foreign country. I think the reason for that hardly needs stated, but it is that if you're facing a well-founded fear of persecution from your own government or a government you're in the territory, and the governmental authority or the authority that's there starts to target you or persecute you for maybe your political opinions, your ethnicity, or for whatever reason, you have, as a matter of your individual human rights, regardless of treaties that the state, your state, or another state has signed, it's part of customary international law, it's part of the unwritten code of international law that's not disputed at all. You have a right to seek asylum. So then, that opens up a lot of different questions. There's a difference between individuals seeking asylum, and in which case they have to either prove that they have a well-founded fear of persecution, which can be sometimes difficult to prove, or depending on the state, some states are much more welcoming and say, listen, if you're fleeing from generalized violence or war or natural disaster, for example in Syria, you may not be being specifically targeted, but you still are at great risk of life, limb, and liberty being taken away, that you should be protected, at least till the danger passes. So, nothing of that is, I would say, is controversial. It's very well established in international law. What I think is, the difficult questions arise when we talk about economic migrants. Some people may be wanting to just flee their own countries because there's very bad unemployment and they're looking for better opportunities. Economic migrants don't have the same rights as refugees. The thing I'd like to underline before we go on to your other questions is that at least a person shouldn't be turned away back to their country where they're facing a danger. So let there be a refugee determination process. That is what international law demands. That is what the United Nations High Commissioner for Refugees determination process recommendations are, that people should be judged, there should be a determination process individually to determine whether the claims are real or not. And then, if a person is being targeted or if they're fleeing perhaps from generalized violence or they're under threat, then it should be let in and taken care of, because that's a basic human rights, basic humanitarian consideration. So whether they are also, this was part of your question, are they also part of the power politics and is it a political issue and all these things? Anything that's a serious issue that voters care about is a political issue. It has to be decided by the public decision-making bodies, by the legislature and by the executive, etc., etc. So, of course, these are inescapably also political issues. That doesn't mean that they're completely just a matter of politics. There's law involved here, and the law is very clear, as I stated. That there is a right to non-refoulement, which is not to be turned back. It's a legal obligation on every single state. And domestic considerations do not provide an excuse for that. That's also very well established in international law. Are they an object of political considerations? Yeah, I guess so. I guess that's true for a lot of different issues, humanitarian issues. I would rather say they're, the subject of debates and humanitarian consideration, power politics. That often does figure into it when you have large refugee outflows, when you have conditions that big powers may be creating by bombing the hell out of a country or another, and that creates refugee outflows. Or one country like Turkey decides, saying, "Listen, we're going to open our borders because you're not giving us the deal that we, you're not honoring a deal that we thought we had with the EU, etc., etc." Those are all political maneuvers. They're not very nice. They are using refugees as pawns, and so I just leave it at that at this stage.
Fine. Since, to be honest, the whole international law concerning refugees and the right to be protected was somehow is a concept of a situation where we are thinking about individuals or some numbers of individuals coming. However, when it starts with the masses really coming, then the political climate in Europe was significantly changed in the past years. So after the Willkommenpolitik started was initialized by Mrs. Merkel, we had a backlash in Europe, and since then we are living with this backlash. However, this wave was insignificant compared to the number of Europeans living in the EU, completely insignificant. We are talking about 0 point something percentages or 0.0 something. We still do have stories about threats, about replacements, and this was really an interesting point for me. What's your opinion, would the international law survive this serious backlash and political pressure? Is it resilient enough to survive? What happens if we have so many countries in EU simply rejecting to honor their obligation?
International law is not a regime that exists over and above the will of states. It cannot be reduced to political will, and political. It has some kind of objective existence in terms of norms, because that's what the objectified consensus is among states. But if states do not, in general, decide to follow international law, it could, over the long term, start to undermine international law as an institution. And we can talk about it with regard to the refugees, or with regard to the use of force, with regard to many different areas. So obviously, the more that the legal norms, whether at the domestic level, or regional level, or international level, are followed, of course, then that tends to strengthen the institutions. If there is widespread, neglect or deliberate breaching of the law, then at a certain point, if it becomes very widespread, then you might consider that international law, being a weak system, is not being followed in the main. But I want to make one point, and that is that legal norms at any level, just because they are broken doesn't mean they don't exist. So yes, the EU can. EU countries may start to have there's a backlash. There's been the Willkommen policy gave rise to some right-wing vocal dissent and even some violence, and these things can happen. But the norms are still out there, and they're still being followed in the main. Principally, they're being followed. But it's true. I mean, you raise a very good point, and that is that if the EU or other regional bodies, regional arrangements, if they speak one set of norms and then they don't follow them very well in practice, or these things then they start to break down a bit. But that's a longer game. That's a more you have to see quite a bit more before that happens. So I wouldn't say that international law is about to implode or about to dissolve, but certainly I'd like to see much more compliance of international legal norms across the board, for sure.
In this respect, I must say, so I will just hand over to Davor now. In this respect, I must say that we were making some talks in previous weeks, and basically one of the key fears would not be epidemiological situation in the world. However, the ecological situation, the spreading of Sahara, the climate changes happening in Africa, and the potential really push of people that cannot live, that cannot, in these unsustainable circumstances, if this would make a high enough pressure in Europe, we are all afraid that joined with the pressure for the economic redistribution that's happening simply right now in the rich societies, we could be facing up something like neo-fascism, like if you want to prevent the power and economic structure, you take a lot of xenophobia that's at hand, and then you make some kind of dystopian system. So Davor, what would your comment be about solidarity? And because the whole concept of humanitarian law is based on solidarity with the people in need. Now in COVID crisis, we have seen that solidarity was on a very low level, even between the people of EU, the nations of not people, but the states of EU. And it obviously shows the suboptimal system, that this Westphalian state system is not definitely the best one when it comes to the global needs. But what would you say? What would be your comment about the solidarity? What could we expect in future if something like climate changes pushes for another round of refugees?
Right. Well, many of these, first, just a couple of comments related to the previous discussion and the international law. There is something paradoxical almost about international law and attempts to impose it. On the one hand, there are some noble ideas behind it, and the major one is to limit the power of the nation state and to establish some kind of order or relationships among different states in the world in order to protect and guarantee certain rights, primarily rights of individuals, but also certain rights and the way states and other subjects relate to each other. The problem there is that, of course, there is no force apart from political entities that agree to a certain extent or not to impose certain legal measures to make powerful states act this way or the other. And in that sense, a lot of those rights are more or less fictional or work as virtual real. So something that is virtual, but has power to change reality only insofar as people really believe in it, and then make, for example, certain states obey to certain rules. But of course, the problem is that you don't have any instruments to make superpowers, extremely influential big powers, states, to actually obey to any of these legal obligations, even if they formally subscribe to them, and in many cases they even don't do that. So very often, as it's the case on a national, but even more on international level, the right is subject to political power and regime of power. So the right is there to protect the weak, in theory, but very often the protection of the weak depends on the will of those who have the power or the general population to put some pressure on those instruments of power. And this is what we also see when it comes to migrant, or I prefer to call it refugee crisis, that very often now European states being affected by that go back to the idea of nation states, and then they simply say in many cases, well, there are these rights, but they are more or less abstract, and they can apply to them only insofar as they enter the soil of our state, so our sovereign state. Therefore, we want to let them enter, and therefore we are not in charge of any of this. So that logic has been applied in certain cases in European states, and very often public intellectuals, those of more conservative orientation, argue for that. And this, it really creates some serious questions about what kind of values do we want to be leading values in our societies or in the world as such. Very often we can see this conflict between the crises that affect everybody, different states and peoples in those states, and those attempts to actually respond to those crises by going back to the idea of sovereign nation states that in itself is, of course, questionable whether that's possible in the world we live in today.
Now, when you mention international law, I will start now another topic, Mr. Sunga, and maybe try to connect the two. And this is my old fascination with the international criminal law. And you are sitting in Rome, which is very important beside Hague in this respect. And the experiences of ICTY, so International Court Tribunal, so Criminal Tribunal for ex-Yugoslavia, what we were witnessing there was that the prosecution used to use evidences provided by the powerful states. And on the other side, those states were not in duty of giving all of the evidences they would have on a certain topic. And that would be a big discrepancy that we could have witnessed. So basically, in a regular court procedure, executive is obliged to hand over all the evidences they have. So whatever you have, regardless of the fact it goes in favor of this or that side, you simply have to hand over. In these cases, you can make a nice patchwork to hand over whichever you like to hand over, and then to make, so, and I cannot resist the feeling that in ICTY, I have never seen anyone convicted who shouldn't have been, ever. Personal statement. On the other side, another personal statement, I know for many of those who were not even mentioned, not to say convicted, and that should have been there. And for me, the key reason is this ability. So we are sovereign when it comes to one aspect, so we can sovereignly decide what we are going to hand over, but then this international tribunal will decide. Somehow this is it play around of justice, this non-universal status?
Well, I want to maybe, you wanted to connect the two things, and maybe I could make a comment a little bit that covers both Davor's very interesting intervention and the question you just raised about the ICTY, and it centers around both of these things, sovereignty. Now, sovereignty, and you mentioned Westphalia, the idea of this states coming up and being sovereign and equal under international law, and we know the history of that since 1648. There are some exceptions to sovereignty. One of them, first of all, is human rights. Human rights does not fall within exclusive sovereign jurisdiction. And the reason I can tell you that very confidently is very simple. It's in United Nations Charter, Article 1, Paragraph 3, elevates human rights to a matter of international legal concern. And just to remember that the reason that was done was not because states like to be criticized for their human rights violations, although they these days accept to be criticized even if they don't like it. It's because after World War II, it was realized that promotion and protection of human rights could not be left to sovereign jurisdiction of domestic states, of domestic jurisdiction, sovereign states, I should say. So, in other words, if you leave it to Nazi Germany and say, well, it's no problem, this is not our issue. Sorry, that's an international matter, because when you violate the rights of individuals and minority groups in a country, this can destabilize the situation so badly. Not only is it wrong in itself, but number two, it causes great regional instability and international threat to international peace and security. And you know that very well from the Yugoslav experience, or from Rwanda, or from anything else. So human rights had to be elevated as part of the United Nations peace strategy. Otherwise, we're going to go right back to a resumption of World War II. So it was very urgent. The first purpose of the United Nations is maintenance of international peace and security. And secondly, related is also human rights promotion and protection, which is not a matter of sovereign states only. Countries, when you get down to it, it's up to them to apply and implement international human rights standards so much at the governmental level, but the obligations that they have, and their legal obligations, are at the international level. That's number one. Number two is that international criminal law, since way back to ancient China and India, thousands of years ago, it has its roots that go all the way back and all the way right up until the present day, to say that certain types of crimes, certain types of acts have to be qualified and have to be understood and recognized as crimes under international law. It doesn't matter what your jurisdiction is, who committed them, and they have to be prosecuted and punished. Now, your right to raise imperfections, or maybe even some more serious faults of the ICTY, and one can do the same for the ICTR. One can complain about the operation of prosecutorial discretion and the operation of courts and the use of evidence, etc., in just about any court, and one should do it. That's what keeps the court on its toes every time. Justice is not very easy. It's not very easy to do. Justice is very, very difficult. It's hard to. There was no way the ICTY was going to get everybody. Rwanda only prosecuted 70 people. There are thousands of perpetrators. But the purpose is to say, when domestic jurisdictions are unwilling or unable to prosecute really serious crimes that are so serious that they're recognized as crimes under international law, there has to be an international level criminal tribunal, maybe an ad hoc one like the ICTY or ICTR, or a permanent international criminal court. So the rationale behind it is solid. I think probably you agree with it. How it actually, you mentioned specifically that some of the big powers chose to share some information and not others. Maybe some of that other information might have been exculpatory, etc. I agree with you about that. That's a concern of mine as well. When governments try to manipulate an international organization, an international criminal tribunal, wherever it is, it's a big cause of worry, because then that is going to possibly undermine, in this case, international criminal justice or international justice. And it's difficult sometimes to resist that. The ICTY at least had very strong powers, because it was established under the Chapter 7 powers of the United Nations Charter by the Security Council. Its rules were binding on all UN member states. And there were judges and brought from all different countries. Really didn't know where necessarily Yugoslavia was on the map necessarily. I mean, they didn't have any connection, etc., with the conflict or any particular bias. And the staff equally is brought in. I think they had 110 countries, I don't forget the number, but it's a huge number of different nationalities, and prosecutors from different places, etc. So I didn't find that, because there's allegations also of bias and partiality, etc., etc. I personally haven't been very convinced of that, but I have seen, and I agree with you, that the big powers try to get their way with the ICTY one way or the other, whether it's the United States or Britain on one side or Russia on the other. And I don't like that, and it's got to be resisted by staff and the people who follow their principles, by judges, and I think they managed to do that most of the time. But there's certain other things that bother me. I mean, nobody was prosecuted for the NATO bombing of Kosovo. I think there could be some war crimes cases out there where they should have at least been brought. If you want justice, it should be very, very even-handed. And if some NATO powers are involved in war crimes in one way or another, they should have also been brought before the ICTY. So there's a lot to complain about, but I would rather have an imperfect, even flawed International Criminal Tribunal than not have it at all.
No,
and that
that's
people
for
get
sure.
away with murder.
That is definitely for sure. I would say I told you in the beginning that I don't have criticism against any judgment, more or less, that someone was prosecuted as a war criminal. Only elect some people there. That would be my main concern. However, the key fear, to be honest, that I honestly have is when you mentioned Westphalian concept, is that we are using 17th century concept in solving 21st century problems. And all of us living in Europe in this moment, I would really be afraid of this overemphasizing of national sovereignty on expense of national sovereignty, on expense of EU sovereignty, or on expense of international principles. And this is something. And when we talk about international justice, let's go to primordial sin, basically, that we know in the last 70, 80 years. We should talk openly, I suppose, whether Dresden bombing, was it a war crime or not. So,
sure it was.
Having in mind that Nazi regime was probably the worst thing, at least in my knowledge, the worst thing that appeared on the face of the earth. Nevertheless, the bombing of Dresden, then bombing of Cambodia in I think it was Nixon administration. That a war crime? So basically, what
about Nagasaki and Hiroshima?
Hiroshima, of course. And what we know as a pattern of behavior is that who made it is a very important thing, unfortunately. And that national sovereignties were covering themselves, their traces, in order, and then basically really not allowing international principles to come on stage in full. And yes, I agree that it's better to have this non-perfect system than not to have it at all. But I would strongly advocate, and this is a question for both of you, maybe Davor first, if you agree that we should be really in support of more international entities that would support international values, having in mind that COVID-19 is probably only the beginning, or only a slight warning for the potential international crisis that we will or may be faced in future. Having in mind the level of globalization, the population that we have, I suppose much harder challenges are ahead of us. If we would not be equipped with the proper universal level, or maybe this regional EU level bodies, we would not be able to respond. Davor, what's maybe...
Well, a couple of things just to say about the previous discussion. As much as I think we all admire the existence of certain international norms and, let's say, human rights, something should be said about that. First of all, Lyal described the context out of which the whole idea of universal human rights came, and it's perfectly correct. The problem there is also that United Nations Declaration on Universal Human Rights is a result of political consensus. In other words, human rights or any other kind of legal norms never fall from heaven, or at least nobody seriously claims that that's the case. It's not by some divine declaration, or it's not there just as some kind of natural thing. It is a result of a political decision, and those human rights that we have now, or most commonly how they are most commonly understood, going back to the UN declaration, they are there only because certain states agreed on them and left out some other things that they didn't think was important at that time or that interfered with their interests and so on and so forth. So those human rights are something that's politically conditioned, and it can be, and I think it should be, expanded to include many more things than they are written in this original document. So that's one thing, and that's a problem with any legal norm, that I know lawyers very often like to think of them as ontological things, and sometimes it would be nice to have them as ontological things, but unfortunately that's not the case. Unfortunately, they depend on political power and political will to be protected and to be enforced or not. And that's also then the case when it comes to these international tribunals. There is something imminently problematic about how it's implemented. I do agree that it's a very good idea to go after some of the major war criminals in the world. The problem is, what kind of concept of justice do we have in mind when we know in advance that that justice will be highly selective? It won't be universally applied. In other words, in the case of international law and international tribunals, the only way to impose and reinforce these norms and go after those who are mass murderers, commit genocide, and so on and so forth, is that powerful states allow that to happen to less powerful states and less powerful agents. In other words, powerful states always excuse themselves, and that in advance creates this situation of injustice. No major perpetrator of major crimes after World War II has been actually brought to justice. More minor ones, yes, those who either operated with support from some powerful agents or didn't have that support and so on. But most of the major crimes that have happened over the last 50, 60, 70 years have not been actually brought to justice or any international court, and that is a problem. So it is similar to a situation within a state when you would have a legal system that would just go or primarily or 80% of times go after poor and those who are actually don't have power to defend themselves, while the rich and the influential within a society stay in the privileged position. No matter what they do, they won't be brought to justice. So I wouldn't call that a system of international justice. I would call that a system of injustice, both locally and internationally, with a full understanding that even those who are poor and they commit some major crimes should be brought to some kind of institutions, to the institution of the law and the court. But that is just very one part of the story. It actually creates an illusion of some kind of system of justice, while in actual reality we talk about system of injustice. And this is something that was supposed to be resolved through United Nations. And going back to your question, how to deal with that, well, the idea of the United Nations was to actually create this international institution which would be capable of dealing with all the complexities in the world, but through institutions of nation states, which is important. So in a certain sense, the currently existing system still relies on nation states. But if we go back 50 years ago, we understand how and why that evolved, because many countries were emerging out of slavery, emerging out of colonial rule. And the idea was, of course, that bringing them and their representatives to some kind of world government would actually guarantee or was meant to guarantee more freedoms and more justice and more rights to those who are coming from the so-called third world countries. The problem back then, and of course nowadays, is that still we don't have mechanisms that would be able and efficient enough to make the super strong in this international community, so-called, to follow any kind of justice or legal norms.
would you refer to this? Are we going to see hopefully one day more efficient international institutions? What's your feeling? Some universal ones to say.
You're asking me or Lyal?
No, Leonel.
Lyal.
Sorry,
Yeah.
Lyal, sorry.
Okay, and first of all, Davor, I think, very eloquently put his put the hit the nail on the head, and it's a big challenge in terms of the legitimacy of international criminal law, and that has to do with its efficacy. Is it efficient? Does it work? And two, is it fair in the large sense? Procedurally, the cases, there's a lot of procedural fairness, but he's raising a larger challenge about selectivity, because if justice is selective, justice has to be selective in the sense that it's going after perpetrators and not the innocent. But that's not what he meant. He meant it's arbitrarily selective. It's arbitrary because you have big crimes being committed by big powers who seem to be beyond the reach. And we're thinking we can talk about United States, we can talk about Russia, we can talk about China, who are not members of the court. And they also have the magic veto at the Security Council. So they have like a get out of jail card, free card. Now that begs another question. And by the way, UK and France are members of the ICC, and UK, they're big powers, but they have agreed for their own good and for their own legitimacy and their smaller powers to go along with international criminal justice, to support it, and that's a good sign. So it's not all powers are doing this, but still, Davor's key point is a really excellent one. And that is, and you have this in domestic law too, domestic criminal jurisdictions, is that you get in. It can be very efficient with petty crimes and this kinds of things. When you have white collar crime that injures thousands of people and hits their pocketbook, and fraud and these kinds of things, they have great lawyers. They have some way of getting around it. And it's a challenge between law and power, justice and power. And power and justice in international relations, just like at the domestic level, but it's even more complicated at the international level, is a really difficult issue. So I wouldn't underestimate the force of the arguments that Davor's given voice to just now. And I think they're a really strong possible challenge to justice. My solution to this would be a little bit different. Instead of saying, well, therefore the system is illegitimate, I would say that it's only partially legitimate, and the solution is to, as much as possible, try to strengthen international criminal justice institutions. Not so it can only go after some people, but so that, hopefully the United States will sign on to it. Did you know that on December 31st, 2000, Bill Clinton, that was his last day of office? He signed, the United States signed the Rome Statute of the International Criminal Court. And the Pentagon was against, because they want to have the American exceptionalism. They have lots of peacekeepers and also American bases all around the world. They don't want to be subject to international criminal jurisdiction, which is absolutely a scandal, because the International Criminal Court only exercises jurisdiction where the state, complementary basis, is unwilling or unable to prosecute a national of that state, or if it's in the territory, for things like, well, the crimes are crime of aggression, starting an aggressive war, genocide, war crimes, crimes against humanity. So my question for the United States is, for that matter, Russia, China, or India hasn't joined either, neither is Pakistan, neither are some other countries. Are you really saying that you're unwilling to prosecute your own nationals? Or are you unable to prosecute? All these countries are able. That means you're unwilling to prosecute? the excuses that they've given, John Bolton, when he was National Security Advisor, now, quit from the Trump administration, but the Pentagon generally has always said, well, it's a political court. The prosecutor's political. No, it's not true. There's lots of checks and balances in the court. And why do other countries have to be subject? When they don't have to be, they signed on to it because they believe in international criminal justice. They think it's important. And they have the confidence to say, well, if for some reason we're not able or willing to prosecute our own nationals for these extremely serious crimes, we better have the help of the ICC. So definitely this is a serious issue. But it goes back to something else. And that is something really very basic. And that is, like so many countries, 123 countries are members of the ICC, and they do it, the members, because they value international peace and security. And international criminal justice is an imperfect, but it's an important ingredient towards international peace and security. So they understand that. All the EU, just about every country in Latin America, Central and South America, Canada, some Asian states, lots of African countries have joined the ICC for that reason and shown a lot of wisdom in doing that. Now, the big problem, the root problem, is that 5 countries have a veto over international peace and security action by the UN, and that is something that's a problem that was created by these victorious powers, as World War II came to a close, and it's solidified there in the United Nations Charter, and you can't amend the UN Charter. It's not just by numbers. You also have to have the assenting votes of the permanent members of the Security Council even to get amendment. So reform of the Security Council is extremely important, and that would solve a huge number of problems. Maybe Germany should be a member. Maybe Nigeria, South Africa, Brazil, India, Pakistan, Japan, and maybe water down this veto power, maybe so that you have 2 or 3 vetoes before you block action, not just one, country. Like, why isn't there action on Syria? China and Russia veto. Why isn't there action on Israel? So many resolutions. The United States. Each one of these permanent members have protected themselves, which is not the idea of the veto power. You're supposed to maybe have recused yourself from it. That was never clear in the UN Charter. But instead, they protect themselves or their friends and their friends. So that's why the United Nations, which has all the powers in the UN Charter to do really strong action, without the strong support of its member states, and especially the most powerful ones, the veto wielding powers, you have a real problem there. So we're in urgent need of UN Security Council reform and a revamping of the UN Charter. Unfortunately, I think what's going to happen is that we're not going to see that reform until there's a crisis, because there's just not the political will. Meanwhile, countries all around the world are chipping away at the international rule of law, and I find that very, very worrying. So to your initial question, which is, don't we need more institutions? I'm not sure we need more institutions. We have a lot of institutions, but they have to be strengthened, and for sure they have to be reformed. And first and foremost, the UN Security Council and the way the UN works, because it's really out of date in that respect, and some others as well.
Okay, let's see what's ahead of us. Thank you for having you today, Lyal. Let's see whether we are equipped. I'm sure we're not, but let's see whether we will be equipped for the 21st century challenges that are ahead of us.
Just a final comment to, and I like very much the way Lyal kind of mapped out these issues and potential solutions. And one thing that also will need to change is our predominant understanding of where the problems are. Because since World War II, we are very used to the idea that we need primarily these laws and systems in order to protect either countries or individuals somewhere there, in the third world, because they are, developing, and they have all sorts of primitive systems, and they are very capable of doing all sorts of insanities, while we have democratic countries, enlightened countries in the West that primarily whose responsibility is to take care of these laws and rights, and of course the rest of the world. While in reality we are seeing more and more situations where actually some of these third world countries are there to protect rights either of individuals or stand for certain rights on the international scene against what's happening in many of the Western countries and so-called democracies. So this is also some adjustments that we'll need to make mentally and also in the school system, if you will, to face the challenges that we are in right now and that are ahead of us.
Yeah, I suppose this is in the definition of universal now. So that was basically the hope. Okay, good to have you here. And
thank you.
Nice to see you this time, and hope to see you next time in the Global Living Room.
Wonderful. Thanks very much for having me in your living room.